Hi, everybody. So, thank you for joining us, and very excited about tonight because I think that we have fabulous panelists here. And regarding, everything we all know, California legislation, K-12, what the world and what the landscape is. We're here tonight to shed some more light on it. Specifically tonight, speaking about both new K-12 legislation, such as AB 715, what it means for Jewish civil rights in the classroom, anybody on parents, advocates, et cetera, et cetera. We want to really walk through, what it mandates, how you can advocate for your child, et cetera, et cetera. And thrilled to have three amazing panelists here today. Firstly, we have Dylan here. All of you might know, especially in California, I think Dylan is extremely well known. CEO of Israeli American Civic Action Network. Dylan is a force, constantly really front lines activism, working, just hand in hand or really leading the fight from what we've seen here at End Jew Hatred in California. Dylan, thank you for your work. The way that you engage in key policy and legislative initiatives is amazing. And you just go full force ahead and you seem to be everywhere all the time. So thank you for that. And I'm excited to hear from you tonight. And I'm sure everybody is. Then we have our one and only Gerard Falidi, our senior counsel at the Lawfare Project, also extremely involved in End Jew Hatred and our civil rights movement. Really the brains behind nearly everything we do here. So, Gerard, beyond thrilled to have you. And then Ilana Cohen, so happy to have you here. Founder, in addition to many other hats you wear, founder of Emmett Legal, a law practice dedicated to fighting anti-discrimination in California K-12 schools. So really, I mean, what better fit here to discuss both AB 715 and another bill that we will hear about, but really discussing it and figuring out how we could really look for the best way to advocate for our kids, look for problems within curriculum, et cetera, and really just ensure that our children don't lose their way throughout the K-12 world. So by the time they end up on college campuses, they're already lost causes. And we want to ensure that we have the tools that we need. We want to help facilitate that. And thankfully, we have three experts here to walk everybody through things. So I guess let's start. Dylan, do you want to start discussing just everything that's on your mind and how you've been involved and shed light on everything for us?
Sure. So thank you, Michelle. Thank you for that amazing introduction. The check's in the mail. That's a great pitch. Thank you for the warm introduction, and great to see everyone tonight. Great to be with you, Gerard and Ilana, and everybody watching. This is an important discussion, and it's actually a great night to have this discussion because there are some breaking legislative news that we'll talk about tonight. First, though, I'll talk about what is in existing law now through AB 715. And then as soon as Gerard and Ilana speak in detail about the legal side of that, I'll wrap up with a new piece of legislation called AB 2159. So that was just introduced. I haven't been introduced yet, but it's been publicized as of yesterday. So just to kind of set the table a little bit for those who may not be familiar, AB 715 is a piece of legislation that was introduced last year in the middle of the California legislative session. I want to give a little bit of legislative history on this bill so that you understand how we got to where we are today, because that impacts the story that Gerard and Ilana will tell about the legal side of things. In California, the legislative session starts in February, generally every year. There are bill deadlines that happen around the end of February, and committees generally begin this time of year. So in about a week or so, policy committees will begin in the state of California. Last year, the Jewish Caucus considered actually two bills. It wasn't just AB 715, but it started with AB 1468, which was another bill focused on ethnic studies and adding some parameters around that area of study. There was a diversity of opinion on that bill. My organization and myself were not supportive of that bill, and we were advocating for a stronger anti-Semitism bill to be considered, at least, especially given the climate that we're seeing in K through 12 public schools following 10/7, which is to me is a historic surge of Jew hatred that we're seeing across the public school system, across the country, and especially here in California. Um, so in mid-May, or at the end of May, early June of last year, the legislature introduced AB 715. And this is important because what later on, when we talk about AB 2159, which is the new bill, it's essentially the anti-AB 715 bill that was introduced yesterday. Um, there were votes taken on that bill, AB 715.
Okay.
There were votes taken on that bill by the person who introduced this new bill, which is meant to uh, essentially repeal major provisions of AB 715. But the substantive part of that piece of legislation was not considered until a vote that happened in mid-September. So you will hear, and you heard a lot of chatter around the bill passed unanimously out of the assembly. There were no votes. That's because there was no bill in the assembly when it first passed off the floor, and before it went to the Senate. So in all fairness, AB 715 was kind of considered under the gun a little bit with the clock ticking. There were legislative deadlines that condensed the hearing process. I've been a lobbyist in California now as an American lobbyist for at least 15 years, and I've never seen a legislative session like that, at least in California, and a bill go through like that, especially on something that's so consequential. So AB 715 went through a challenging condensed timeline, and it really wasn't, in my estimation, considered carefully by legislators. And in fact, many legislators, and this is important later on when we talk about AB 2159, many legislators voted for the bill on the floor with the promise, and they said this on the record for a purpose, that there will be fix-it legislation that will be considered later on. So I
What
say,
does that mean, Dylan, for us? So what does that mean at that point? So meaning they voted for it as is with the promise that there would be an edited version in the future?
yeah, so it's pretty, it's kind of, when I saw language like that being used on the floor of the legislature last year, that term "fix it" legislation had
Right.
been used so often that it tells me that there's something broken in the legislature. Now, last year they had two special sessions around Trump and the fires, and so that kind of pushed things a little bit in terms of the calendar. But nonetheless, the legislature simply is not functioning properly because you don't pass a bill
Right. It doesn't.
promising to make changes within a few months. So again, that's a term that you hear only under the rarest of circumstances, typically in a legislative process. The fact that we heard it so often, and especially with this bill, concerned me. And that issue really boxed legislators, policymakers, and the community into a corner. And uh, so that's kind of the negative side of it, I guess, and that's leading us to where we are today with the AB 2159. I want to say some of the positive things about the bill and about the legislative process. I think it was important for the Jewish Caucus, the California Legislative Jewish Caucus, to even be open to considering this bill. We had to push hard again to get them off of an ethnic studies bill and onto a anti-Semitism bill. So the fact that we began that conversation, I think, is a very important thing. We're going to continue that conversation this year, it seems like. It's been a long process, but I think there are people who are committed, and they really went. They put themselves on the line politically. It's an election year this year, to support this proposal, and they fought, some of the nastiest blood libels and some of the myths around Israel and Jewish people. There's a lot of disgusting stuff that went on in that legislative session. So uh, that we had members of the legislature willing to confront that and overcome it and push through to get this bill to the end shows I think an important level of commitment from some members of the legislature. But um, look, I think that it's going to be a challenge. I don't want to skip ahead because now there's I have a lot more to report on the back end, but
Right.
that's essentially how AB 715 started. It's also important to note that here in California, we went through an entire year where K through 12 was ignored essentially at the state level. There were no serious legislative proposals in 2024, immediately post 10-7. There were many that focused on college. I would argue they were marginal changes in the law. And I'll just end by saying in California, the biggest problem we have is, and I actually just before this, I was on a call with another legislator, and I said, the legislature forgets it has two jobs. Lawmakers are not just lawmakers. Yes, that's one of their jobs, but their other very important job is oversight. And in
Mhm.
California, where you have one party rule, where, for example, I was just in Sacramento last week, there were many legislators of the Jewish caucus who are now running for statewide office. Ben Allen, who is a member of the Jewish caucus, is running for insurance commissioner. Josh Newman, who was on the Jewish caucus last year, is now running for state superintendent of public instruction. Why would members of the Jewish caucus hold the California Department of Education to account when they want that job or when they want a similar statewide job? So we have a big problem in California with oversight. And we're lucky to have great people like Gerard and Alana as lawyers to help go through the judicial branch and hopefully get some better outcomes. The legislative side in California has been tough. And as soon as Ilana is done, I'm happy to loop back and talk about new legislation again that was just introduced yesterday to roll back, essentially repeal major provisions of AB 715.
Right. Wow. Thanks, Dylan, for that, very informative, really good brief summary about how we got to where we are now. And, and I think when you loop back afterwards, it's all going to, come together for us all to see the full picture of how things work. Gerard, I'm going to turn it over to you now. Coming from the legal realm, legal and activism sort of intertwined. I'm going to turn things over to you.
I will say that, and I'm welcome for Dylan and Alana to step in if I'm misremembering AB 715. But I think what I find striking about that legislation from a legal perspective is how broad it actually is. I mean, we're all familiar with the concept that this creates an office of anti-Semitism prevention coordinator, and it obligates the creation of an office of civil rights. So this basically refines a complaint system. But the bill itself goes beyond that. It prohibits instructional materials that are discriminatory or biased. And it requires factually accurate instruction. Two things which really go into the heart of also ethnic studies, which I think is one of the reasons why we did get a number of Jewish organizations to switch focus and support this. Because while ethnic studies is definitely not going away, if there is a method to go after the curriculum that's problematic, this provides the legal framework to do so. So what this bill does, it does make that distinction between curriculum that can be challenged, and it obligates an investigation into problematic curriculum, which is not something that was uniform or standardized before, and not something that had the power of state legislature. So this is really something that was novel and unique, and I think this is why there's so much pushback. And what we saw right after this was signed into not even after it was signed into law, but before it became effective on the 1st of January, we already saw a lawsuit filed seeking an injunction to stop this from going into effect. And as one would expect, this was filed by I want to get the name straight, the American Arab Anti-Discrimination Committee, because CARE is not enough of an organization. We need more like it. And also I believe it was four public school teachers across the state. The named plaintiff is actually a middle school teacher at Berkeley, and also by a number of students as well, by I think 3 students. And this was litigation that sought to basically prevent this legislation from taking effect in the 1st of January. And they argued, among other things, that this was a violation of the First Amendment, that this was procedurally unsound, that this legislation was both too broad in its definition of anti-Semitism, but also too specific because it used the Biden-era national strategy to combat anti-Semitism, which included IHRA. So on the one hand, they were arguing that anti-Semitism was not well defined, but at the same time, they were arguing it was too well defined. And basically, they were making the argument that it's a First Amendment issue, that this prevents teachers from using the materials of their choice. And the court rejected these arguments. A federal district court judge, appointed, by the way, by President Biden, if I remember correctly, called BS on this and saying that it was unlikely that the plaintiffs would succeed on the merits at trial, that this was not right to be adjudicated. But this court case also, the judge also made some very specific findings. And one of these is that teachers, as plaintiffs, they do not have a First Amendment right while teaching. The court made it clear that when you are in a classroom, when you are employed and you are teaching on behalf of the government, you are speaking on behalf of the government. So this concept of government speech takes over, and the government is allowed by law. This is a constitutional. This is something that the Constitution is found to maintain. It's not just private citizens who have a right of speech; it's the government itself. So when a teacher is speaking in a classroom, the court found that that is falls under the government's right of speech, not the teacher's, and that the teacher does not have a First Amendment right to basically use whatever curriculum materials that they want, and that the curriculum material is a choice by the school, by the government that needs to be adhered to, which is why the state could pass legislation regulating it. All of which to say is that this really upset a lot of teachers who have been used to this idea of academic freedom and free speech. This goes back to an earlier U.S. Supreme Court case that said essentially that government employees, when you're working and speaking in your capacity as a government employee, that's not private speech. You don't have that First Amendment right. You have to basically say what your employer, the government, wants you to say. But that Supreme Court case from almost 20 years ago had a carve out, a little footnote which preserved the idea of academic freedom. So that's still something that is subject to dispute. That's still something that's subject to litigation. And even though this particular judge said essentially that as a teacher at a public school, you don't have that First Amendment right. You are controlled by what the government, your employer, the school board wants you to teach, and by extension the state, because they're the ones who are issuing this law. That's something that is likely to be appealed or will be continually litigated, because a lot of people think that this restricts the academic freedom of teachers in a public school. And just a little caveat here, that courts generally have been more receptive to academic freedom arguments from college professors, not from K to 12. K to 12, there is more of a government interest in controlling the speech and the conduct in classrooms. So this will be at some point a very interesting case that will make its way to the Supreme Court. But for now, the court decided that there was not enough to issue an injunction preventing this law from going into effect. So the law did go into effect. And as Dylan will come back and explain, now this is what being challenged not just through the legal system, but through the legislative system, coming up with an introduction. I think, who was it? Assembly Member Garcia who introduced this new bill to basically gut the old one. And of course, this is where the Jew hatred alarm bells go off. What provisions do they want to gut from the bill? The inclusion of the national strategy to combat anti-Semitism, the definition of IHRA. This is what they want to cut from it. So clearly the animus is not that this is looking at curriculums. The animus is that this is seen as protecting Jewish voices, or using the IHRA definition. All of which to say that this is, I think, a very good piece of legislation that, if left alone or if implemented in other states as well, gives parents strong tools to challenge the problematic curriculums that we've seen all over the place. There are also weaknesses. There's no private cause of action. You have to go through the complaint procedure, something that Alana is very, familiar with how that works. But it's not, you don't go into a courtroom and sue because there's classroom materials that are questionable. You have to go through a process. But what this legislation does is provide clarity on that process and obligate the process to be followed, which is to say that it provides parents a tool, once they know what that curriculum is, once they know what the lesson plans are, to actually challenge it as discriminatory, and to potentially get changes made.
Got it. So, Gerard, in terms of how you just said once they know what the curriculum is, I do just want to touch on that as well. If anybody listening doesn't know how to fairly easily find out your child's curriculum, I think that is important. We have on our End Jew Hatred website, we have an End Hate in Education landing page. I'll actually put in the chat where that is. I think it's important because we have a toolkit. We have a K-12 toolkit with sort of, it's a how-to. So how to find your child's curriculum, meaning, searching on the web, keywords to search for, that it should be easily found, that it shouldn't be, it shouldn't take forever to find, for instance, your child's 10th grade social studies curriculum. And this is nationwide. So I do want to drop in the chat the link to our NTAID and Education toolkit. Take a look at it and obviously be in touch with anything. But I do think that's one key piece here is in terms of making activism easy for parents. So enabling you all to find, for instance, curriculum, et cetera, et cetera. And now let's turn to Ilana. And Alana, I know that you'll also now talk to, truly being able to advocate and what to look for and sort of what steps to take.
Thank you. Yeah, I wanted to switch gears a little bit and talk about how we can use the legislation that we
Great.
do have since it has gone into
Perfect.
effect and pair it with existing law and legislation, some of which both Gerard and Dylan have spoken about, and see how our parents and community can use it. I actually have a PowerPoint presentation, so unlike these two, who can just speak off the cuff, I need some slides to go with my chatter. So I'm going to share those.
Thanks.
Um, Hopefully you can see them.
Yes, perfect.
Great. So the main takeaway that I want, if you come away with one concept that is clear in the law, is that students have a right to feel safe and secure in school. And what I like to emphasize to parents is that that specifically means Jewish students. It means our Israeli American students, it means our Jewish students, and it means if you have a sincerely held religious belief in Jewish values and Zionism, then you have a right to feel safe and secure in the school. And so we're going to talk about how you can enforce that. So we've talked about AB 715. We'll talk a little bit about some California specific educational codes. Gerard just talked about some of the foundational case law actually that goes into this. And as he just mentioned, when you file a complaint, what happens and when it goes to the California Department of Education, they actually produce a determination, and you can basically use that determination in other California public schools. So there's three foundational concepts that are reiterated through these four categories, which I believe we've touched about all of them, but I want to reiterate that these are the three buckets: that teachers cannot promote their personal opinions and viewpoints in the classroom, that students have a right to an inclusive and safe learning environment, that parents and community members have the right to access all curriculum materials, which is what Michelle was just talking about. So this is a lot of text and I'm not going to read all of it, but what I want to say is that there are a lot of laws that help us recognize what is lawful classroom material and what is not lawful classroom material. And when we talk about materials being inappropriate, that's not just my personal opinion or an organizational's personal opinion. That is actually codified in the law. Now, AB 715 is, like we were talking about, kind of a foundational step in codifying some of this legislation and tying it to anti-Semitism specifically, because AB 715 outlines that teacher instruction must be factually accurate and aligned with adopted curriculum rather than advocacy, personal opinion, bias, and partisanship. Previously, a lot of that language was found in Board Policy 6144, but that's not a law. That's up for each school board to adopt. And many of the large school districts in California have actually chosen to move away from that in order to introduce this political biased content. And so by putting that language into AB 715, they can't get around it.
Got it.
Anymore. Now, of course, Dylan's going to talk about the issues with the attacks on that language, but the point is that right now, and hopefully in the future, we actually have that codified in the law. There are a number of educational codes, like 10 to 20, that talk about discrimination, and they basically all say the same thing, which is that you can't discriminate against students based on their religion, national origin, and ethnicity. And so when I talk about whether or not it's lawful or not, those are the three buckets that students or staff or community can fit into. And lastly, I wanted to point out this educational code that not a lot of people know about, but it actually says that students cannot be compelled to affirm or disavow any particular personal or privately held worldview, religious doctrine, or political opinion. And that means if the teacher says, whatever it is, but let's say Israel's committing genocide, write an essay about it, that would be compelling a student to actually now write something to affirm that teacher's political belief. Now, in that case, it would be discriminatory because you're acting against a student's religious beliefs. But if it was about a political opinion, that becomes a lot dicier because it doesn't fall into the complaint bucket of discrimination. I'll talk about that a little bit in a second, but it actually is a California law. It's just never enforced.
Wow.
So, what does it mean for there to be discrimination? It's a word that I've been throwing around every 5 seconds. There are the protected classes that I just spoke about. It means you cannot target students based on their sincerely held religious beliefs, their ethnic beliefs, or their national origin, which applies to the Israeli American students. And when you say, is this discriminatory? Am I overreacting? I hear that from parents a lot. Like, is this okay? Is it not okay? And I say, you tell me how your student feels. Do they feel isolated? Do they feel targeted? Do they feel silenced? Do they feel like they cannot express themselves or their identity based on what's coming into the classroom? And if the answer is yes, then there's probably discrimination, either discriminatory speech or curriculum content in the classroom or in the school as a general. All of these rules apply to the entire classroom environment. It's not limited to the classroom specifically. So these are all examples that are currently in schools right now that I'm filing complaints about in Southern California. So this is a teacher that wears a keffiyeh on a regular basis, and she's actually wearing it in her photo on
The
the
picture.
school's website. Right now, it's still up. It's now under investigation, and these are posters from around the school, including in her classroom. The board trustees and the superintendent are aware and have tried to resolve the issue, but as you can see, it's ongoing. This came up a couple days ago. This was a part of a Holocaust lesson that is currently was taught this week in a Southern California school. And after the Holocaust lesson, in a US history class, they decided to talk about other world genocides, which of course focused on Gaza and only presented this. This was the only information, the only side of things that the students received. This is an example of classroom materials. This was part of an ethnic studies class, and just while randomly, while going through units, these would pop up just throughout the class. So, oh, today here's the amount of Palestinians that were killed. Oh, let's talk about biases. Oh, here's how many Palestinians were killed today. Oh, here's supplemental resources. What's the most ironic about this is that the class is about ethnic studies. And as you can see here, the unit that some of these popped up in were about implicit bias. And the slides preceding this slide at the bottom were what happens when you only hear one side of the story and what makes it dangerous.
Wow.
But apparently, the educator did not find the need to present multiple sides. The story is completely unrelated. All of these are completely unrelated to the curriculum. And as you can see, are popping up over the curriculum, kind of like breaking news style. But the irony is very apparent here. And again, ongoing. This is from an ongoing class right now in Southern California. So, what do you do when this happens? These are just a few examples of ongoing complaints and issues that are being investigated right now. The first is what you had mentioned earlier, Michelle, that you have to find what's in your classroom.
Right.
Parents are constantly telling me, oh, we have a great principal, so I think everything is going well. Well, you don't know until you check the principal. So probably doesn't know. Because teachers just, as you can see with the breaking news, can just insert it at any point, whether or not it's related. And sometimes Gerard was talking about with ethnic studies, it comes very much into the curriculum as a oppressor oppressed. Now here's your oppressor. So the best way is to check. It's sometimes it's hard, sometimes it's easy, but there's no question that lawfully you have an absolute right. Anyone from any place has an absolute
Okay.
right to see the school curriculum. And means all of it. That means you can see the classroom slides, that means you can see the supplemental resources, and that the learning resources, the instructional materials, this is all codified in the law. There's no question about it. But often when parents ask, the district says no, the teacher says no, or the much more common issue is that they send a 2-page outline of the course that's available online, which is, of course, not particularly useful. Like a 2-page bullet point is not going to tell you what the students are actually studying. And so I would say just ask for assistance at that point. Things go much, much quicker when you ask for assistance. But when you first want to find out, just ask your teacher, ask the superintendent, ask the principal, just send an email and say, hey, I'm worried about blah, blah, blah class. Can you send me the content? Sometimes they will, sometimes you'll need more. Um, but you should look.
Right.
Now, if you discover discriminatory materials like the examples that I just provided, I want to talk about the benefits of filing complaint. And that's outlined a bit in 715, in AB 715, but it's actually long been codified in the Educational Code in California. A lot of states have similar types of processes to file complaints. There's the word complaint can kind of be used generally, like complain to your school when you find that kids are unsafe, and filing a uniform complaint form is actually a formal process. Now, anyone can do the process. It's actually set up so that parents can file them. I have found that process is really overwhelming, and that's why I set up the law firm to help parents walk through these steps. The formal complaint is filed on the district level, so it's not going to your individual teacher. It's not even going to your individual principal. It's going to the superintendent, and now the district needs to look at it. Why is it useful to file these formal complaints? Because it takes work. I know it takes work because I'm filing them, but it's lengthy. It's a whole process. One, it formalizes that there is an issue, that there is unlawful speech. So when you tell the district this is discriminatory, it's put on the record that a complaint was filed on a state and federal level. The districts need to state how many discriminatory complaints were filed. And when you say this is a discriminatory issue regarding anti-Semitism, that is formally noted, and they cannot move away from that. If you
Makes
file
sense.
complaints in the future, you also want to build a record. I don't want to go into this too much, but there's landmark lawsuits right now going on, like with Oakland, because so many complaints were filed and the district didn't do anything, even after the California Department of Education told them to. And that doesn't happen unless you formally file. So each time is like starting from step one if there's no track of these being formally filed.
Right.
It requires the district to investigate. They will hire or they have an in-house investigator, that's usually an attorney, to actually speak with the teacher, review the content, speak with students. That costs them money, it costs time, and it's a formal investigation. There will be a formal confidential investigatory report created. Based on that report, the district will make a formal determination that will outline if the content is discriminatory and if corrective action is needed. So looking back at the slides a few ago, you want the district to say, random pop-ups talking about only Palestinian deaths that are unrelated to the curriculum are probably discriminatory and not good for students to randomly, constantly hear about only Palestinian deaths. So we should say that these slides are discriminatory and we should have repercussions for the teacher. Unfortunately, you won't find out necessarily what those repercussions are because they will be in the um, um, personnel action, which is confidential unless they're terminated, and then they won't be there anymore. It also, and most importantly, allows for an appeal to the California Department of Education. And that's where you get those determinations from, the CDE determinations that you can later cite both to your school and to other districts in California. Um,
But now,
districts,
Alana, I have one question, Alana. So, in
yes.
terms of, for instance, the slides in class, if a parent finds out that that was shown, so are you suggesting to sort of skip that first step of approaching the teacher or the principal, but not filing a formal complaint? Are you saying it's important to make it formal from the start, just so that the complaints are sort of all in the system? If that makes sense, what I'm asking?
It does, yes, yes, it makes sense. It really depends on the situation because those slides that I showed were really discriminatory. Like,
Right.
there's no question that that's discriminatory and really inappropriate for the classroom. And I can definitely see parents in these cases going straight to a formal complaint, which is something that my office files, the formal
Got it.
complaints. I'm not
Okay.
suggesting
Okay.
that parents do them on their own.
No,
It's
no, of course. Right.
yeah.
I guess I'm just
But
asking at what point should
parents
parents, take
parents
the,
usually do first talk to the principal and the teacher, and that's totally fine. There's a 6-month statute of limitations. And if the teacher says, "Oh my God, I had no idea. I'm so horrified. Let me teach a restorative lesson." Maybe the parents won't want to file a
right.
complaint, a formal complaint, and that they'll resolve it informally. I've never seen that happen.
Wow. Okay.
But there's no downside in first speaking with your principal unless they're gonna like tie this up for six
Got
months, but usually they'll tell you within a couple weeks what they're going to do. So for example, if they don't want to show you the slides, it's a good time to think maybe they're not on my side.
Right. Exactly.
But also think of it as you have the teachers union over here, and this is content that teachers are bringing in. So now they're thinking parents complaining, teachers union.
Right.
How what am I going to do for the district, because they have a fiduciary duty to the district, right, to keep the district operating.
Correct.
And so by formalizing it and starting the investigation, it's we start fighting. We have some leverage going up, not as much as the
Exactly.
teachers union, but once the CDE is involved, once these lawsuits come forward after the determinations, and legislation following from these, that starts to tip the scales.
Got it.
Um, so as we talked about a little bit earlier, that AB 715 actually makes it easier to file a complaint anonymously. You can actually always file them anonymously, but AB 715 clarifies that you don't need to show direct harm. So really big deal actually, because before districts would not find something discriminatory unless students said, "I feel personally targeted," as opposed to, well, having a genocide poster up in your classroom should be discriminatory in and of itself. You shouldn't need a student to come forward and say that. Maybe there were no Jewish students in the class. Like, that shouldn't determine whether or not it's discriminatory. It affects all students. But I should also know it doesn't mean file anonymously, say whatever you want, and the district will agree with you. You always need to provide evidence. And so it means you can provide anonymous testimony if you have screenshots. There's a number of things that you can provide to use evidence. I'm going to try to wrap up quickly. I know I've
Great.
been speaking. So when you do file a complaint, just wanted to say what you should expect, which is you need to file it within 6 months. So it does not need to be filed within a week, but it also has a very short statute of limitations, much shorter than a regular lawsuit. Districts are supposed to have the forms and all the information I've covered is supposed to be on their website. They typically do not. Some of them do, but don't be surprised if you don't find it at all. The district will reach out to collect evidence and interviews, and it's really important to ask for assistance so that you can protect students by making their interviews anonymous. You need to follow up to get a determination letter. So the whole point is getting a determination letter, and only 30 days to appeal to the CDE. The CDE will not do any further investigation. So once a student does an interview, that's it. They're not going to go reach out. It's not like a lawsuit with a lot of back and forth. It's just step, 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 step. But you should note the short timeline. Next steps, if something happens in your classroom, like you were just asking, Michelle, informal resolutions are great. But whatever you do, document everything. Every conversation you have, follow it up with an email. Thank you for speaking to me. You agreed to XYZ, and you said you would do it by 1/2 date. Make sure you have firm requests. Don't go in just to say that you're upset. Go in to say, I want this curriculum removed. I want this poster removed. I want to see these records. Something specific that you want that they can agree to in the meeting, and then that you can document that. Establish deadline expectations. Districts love to say, oh, give me another 30 days, give me another 30 days. We can't find these records, even though they were just taught last week. So I need them by this date. Oh, you agree to that? Great. Follow it up in writing. All your follow-ups need to be pleasant and professional, not angry, and also not overly nice. Like, thank you so much for meeting with me. That's their job. So
Right.
there's a nice balance to maintain. And there are a number of different ways that you can escalate matters. Not everything needs a formal complaint. Not everything needs a lawsuit. Some things are just a petition. Some things are an email. Some things are a legal letter. I'm working with Lawfare on one of those right now. So there's different ways to succeed, and figuring out the right path forward is often part of the battle. So lastly, speak with your student. That's the best way to find information, report the incidents, and reach out for resources.
Amazing. I'm actually also just going to put your info at in the chat so anyone can also grab it from there if they. Perfect. Thank you so much, Alana. Well,
Yep.
no, that was great. It was really the how to, what to look for and what steps to take, which is precisely what we need. So Dylan, now back to you. Let's hear the new fun now. What's going on and what we can all do.
Yes, ma'am. All right, I am going to share my screen. Before I do that, I do want to just say, so we're going to talk now quickly about AB 2159. This is a new piece of legislation, again, that is designed to roll back a lot of the provisions that Ilana and Gerard just explained to you. So all the great news that they just shared, I'm going to explain to you the effort now to unwind that. It's a little rage baity, so sorry to end on this note, but that's what we're going to do. Before we jump to the actual screen showing the bill, I want you to understand that this is what is called a placeholder bill. So in the legislature, there are legislative deadlines. The deadline to introduce a bill this session was February 20th. So what legislators will do, they'll put bills like this in, which essentially say nothing. This is what's called an intent bill, that it is the intent of this legislator to submit further text about this particular topic that's being introduced here. It's just a way to bypass the deadline and do things later on after the deadline. So I say this to say that if you go to right now this bill page, you're going to see something that has nothing to do with AB 715, nothing to do with what we've all been talking about, because the legislator chose a little bit of a sneaky approach to take, as I said, an existing intent bill and to totally what's called gut and amend. That's a phrase they use here in California to essentially all of this legislative text. You'll see it probably by Friday evening. This will all be struck in a new version, and there will be completely new legislative language replaced here. So I preface my remarks here by saying that if you go look at this bill now, you'll see something that is this, not what we're talking about. Is that fair? Does that make sense?
Yes.
All right. So in lieu of having actual legislative language, helpfully, the bill sponsor partnered with a lovely organization called CARE to help distribute talking point or a fact sheet. So we actually have on his letterhead from Assemblymember Robert Garcia. He's from the San Bernardino area, if you know Southern California. Um, this is what's a traditional fact sheet that most bills have when they first get introduced. Typically, you'll see it after legislative language is introduced, but again, this is the only official document that we have to evaluate until the actual text gets released. So I'm going to go through this. I'll read it quickly, just from the page and kind of review it. So essentially, this says AB 2159, and I'm going to add some notes based on what happened from 715, just so we understand the context.
Right.
AB 2159 continues California's progress, and consider the language that they're using. This is totally like 1984 Orwellian type framing. AB 2159 continues California's progress towards more inclusive and equitable learning environments by addressing issues resulting in the enactment of AB 715. Specifically, the new bill removes a reference to a definition of anti-Semitism that could include criticism of Israeli government policy. So here they're referencing the provision in the statute that says that the new anti-Semitism coordinator shall use the Biden National Plan to Combat Anti-Semitism. Note, by the way, Biden's name, when you look at this document, appears nowhere in this fact sheet. They intentionally remove that. And they, of course, absolutely mention Donald Trump. So here they're talking about the IHRA definition of anti-Semitism. And of course, people incorrectly claim that definition prohibits free speech or it criminalizes speech, all sorts of extreme irrelevant accusations. To our perspective, especially at ICANN, where we work closely with the Israeli American community, this definition is important for us because it clarifies national origin type discrimination, like we saw in San Jose this week, where those perpetrators so far appeared not to have hate crime charges brought against them. Additionally, this new bill requires the anti-Semitism prevention coordinator to be selected through an unbiased, merit-based civil service process, and removes vague and subjective language that exposes schools and teachers to discrimination complaints. So we'll go through a little bit of background. The California, let's see what the during the legislative process, a broad opposition. Now, I will say this too, by the way, fact sheets on bills are typically not this editorial. They typically speak to the problem of the bill and the problem that the legislation is meant to address. This fact sheet, the reason I'm reading it is because there's actually some very helpful editorializing here that will put in context this upcoming legislative session. During the legislative process, a broad opposition coalition of teachers, administrators, school board members, staff, students, labor unions, civil rights organizations raised significant concerns about AB 715's unintended consequences, while also recognizing the need to address anti-Semitism in schools. Here, the author and members of the California Legislative Jewish Caucus committed to addressing concerns the following year, that's this year, a commitment that was reiterated by Gavin Newsom in his signing message for AB 715. All those facts are true. I will tell you that as someone who watched the legislative process closely last year, over and over and over again, the Jewish Caucus and the authors of AB 715 committed to addressing unintended consequences or concerns or confusion in the bill. And in fact, Gavin Newsom, in his signing statement, he signed the bill on October 7th of last year. In his signing statement, he also noted the bill authors and bill sponsors' concerns around unintended consequences around legislative language. So all of that has been brought forth now to remind everybody who made that commitment that you made that commitment. Now we're going to address it. So what are it looks like three things mainly that this bill does. First of all, it removes this reference to the U.S. national strategy. Again, this is the Biden plan, they call it. Usually most states call it the Biden plan. Now they're intentionally leaving Biden out for political reasons. But in the court case that Gerard mentioned, the judge, Noel Wise, mentioned the IHRA definition and said, you know what, by reference, you're right. The reference of the national plan, and it says shall, not may. They shall use this plan. And by reference, it does kind of reference the IHRA definition. And the judge said that's fine. That's not unconstitutional. And in fact, she further stated that California could decide to adopt IHRA directly if they so chose. they make all sorts of, let's see it here. It says this definition, this is a little crazy. I said we'll have some rage bait. This definition was also the basis of the Trump administration's EEOC subpoenas of the CSU and UC over pro-Palestine protests and the ICE detentions of Palestine supporters practicing their right to free speech. That is a lie. This legislator is lying to you because those protesters were not held because of their exercise of free speech. They were held because they were segregating campus and public spaces on state property. So again, this legislator is lying and twisting the truth. Number two, the second main provision they say in this new bill is to require the new anti-Semitism coordinator to go through some sort of professional assessment, and that the position should have qualifications and whatever. What's interesting about this is, I don't want to get too technical, but this was a very strange legislative process. There was a sister bill or a companion bill with AB 715 called SB 48. And SB 48 added additional discrimination coordinators on things like LGBT, religion, racism. I think there was one more. I can't remember what it is, but these two statutes go together. What's interesting about this is there's no indication that the other positions are being held to the same standard as the anti-Semitism coordinator. That is something that's an interesting divergence, and we want to see what the bill actually looks like. And finally, the discrimination complaints based on vague and subjective terms. This is one of I think the main complaints of the plaintiffs here, or this coalition, where this term factually accurate. I have to tell you, I'm going to love I hope we have a hearing on this bill, because I want to hear them complain about the term factually accurate and how that term is used. So here it says, in addition to the quote factually accurate requirement, which they're opposing factually accurate teaching, discrimination complaints against teachers and instructional materials are based on quote accepted standards of professional responsibility rather than advocacy, personal opinion, bias, or partisanship. I mean, so they're essentially saying we want to have advocacy, personal opinion, bias, and partisanship in the classroom. By the way, even if you repealed 715 in its entirety, there are already strong provisions in California state law that prohibit this. So this just further strengthened and clarified that those existing statutes. But nonetheless, they're attempting to create a new standards here. So they're saying essentially that our side, or parents who are community members who are concerned about advocacy and personal opinion, partisanship, and bias in the classroom, that we are attempting to silence their right to free speech and free expression and academic freedom in the classroom, none of which, as Ilana and Gerard said, none of which exist for teachers in the classroom for the most part. There is this term, professional responsibility. That term is not, according to certain associations, that term is not defined in law. And was pulled from, I guess, a contract in Los Angeles. So we'll see.
It's common in board policy. There's a professional standards provision, but you cannot, if you file a complaint against professional standards, the district doesn't have to disclose anything about it. It falls within the personnel action of the teacher.
Yep. So there were complaints about, at least Ilana, thank you for that divergence between what is board policy and now creating this new term in state statute, which has no broad understanding or definition. So that is the fact sheet on AB 715. I do just want to show you who is supporting here. Very interestingly, SEIU California. SEIU is Service Employees International United California. And then, of course, and SEIU, these are service employees. What's interesting about this co-sponsorship, by the way, is that I believe the head of SEIU California is Lorena Gonzalez. I may be mistaken, but she's a former senator in
Mm.
in California, and it's interesting that weight is being pulled here because you look at the next co-sponsor, the California Faculty Association. These are primarily people who are in colleges and universities, not in K through 12. And
Oh,
again, we saw this through the legislative process last year. The university, I'll try to wrap it very quickly, but the university community came out in strong opposition to AB 715 because again, these are the predatory actors who are pushing this indoctrination on our kids and students. And of course, you've got
Associated
CARE
with liberated ethnic
associated
studies
with.
and the
Yes.
entire, that's the CFA.
Yeah. So yeah, thank you, Ilana. So the CFA California Faculty Association, there's one player in the CFA. Her name is Teresa Montano. She's an appointed official in the Los Angeles County Office of Education. She's also a major player in the CFA, major player in liberated ethnic studies, Ilana, to your point. And she really is the kind of the ringleader pulling all of these people together, including CARE, California Labor Federation, AROC, JVP, and others. One little note I want to just show, just a little interesting fact. Jewish Voice for Peace Los Angeles, but an interesting thing to note, and I'm not saying anything, but Chief of Staff Brendan Murphy for Robert Garcia. Um, if I'm not mistaken, about 4 or 5 months ago, Brandon Murphy was the Chief of Staff for California Legislative Jewish Caucus member Henry Stern. Very interesting that a Chief of Staff for Stern, who helped with AB 715 on the inside of the caucus, is now a Chief of Staff for the legislator who's looking to undo it. What role that person plays in this process will be very interesting to watch. And I just note that for the
no,
record.
that's good to be noted. So here's
Yeah.
Dylan. So what do we do? I know that in our End Jew Hatred action items groups, which we share, a lot of ICANN actions, et cetera, et cetera. We actually shared a Stand With Us action around this, and another organization. It's just
Yep.
slipping my mind. So meaning specifically around this to apply pressure, in
Yep.
that way, that digital pressure. But what else can California parents do in this situation when something like this occurs? Is it
So
showing up? Is it
yeah, so I want to quickly give you kind of a look at that exact to answer that exact question. So this is Robert Garcia. This is kind of we have a pretty sophisticated political intelligence system at ICANN where we're looking at everything all the time, all at once. So I wanted to pull up as we're looking at this legislator, and I hope this doesn't look too intimidating, but I want to pull up the committee, because so right now, Michelle, that those two action items that you shared are calling on the legislator to withdraw his own bill. Now, looking at the fact sheet and who is co-sponsoring this, SEIU, CFA, CARE,
yes.
and again, looking at CARE, again, there's a media release with all these other they put out a media release. This is well organized, planned. It's unlikely that the legislator will pull his
Right.
bill.
Correct.
So we have two, to my mind, then we have two paths. First of all, parents, yes, please be active. And we are working on based on our analysis, we're working on our action. We have a little bit of a different approach.
Okay.
Uh, but there's two approaches. One is the committee. So once this bill gets referred out of, it's sitting in what's called the Rules Committee now. Once it gets referred out of rules, it'll likely get assigned to what's called the Education Committee. And in California, you have to go through typically two policy committees, maybe just one policy committee, depending on the policy, a fiscal committee, and then floor, and then you repeat the same process in the second chamber.
Okay.
Education will be the first policy committee in either chamber. So this bill, being an education bill, will go to that committee. Now there are currently 8 members of the committee. There's one vacancy. So this is and this is kind of a problem because as far as our math looks, it looks like there's a solid. And again, I'm a lobbyist, so I count votes. This is what's most
Right.
important about us. It looks like we have 4 against AB 2159.
Right.
How do we count that? Rick Zabur, who was the original he was the original author of one of the original authors of AB 715. You've
Okay.
got Josh Lowenthal, who is a member of the California Legislative Jewish Caucus, close ally of Rick Zabur. So that's your second vote. Robert Garcia himself is actually on the committee. He's not going to vote against his own bill. Leticia Castillo and Josh Hoover, both of them are Republican members. And we think that with our good Republican relationships, we'll get them, and they're supportive generally of AB 715 in the Jewish community. You have Mia Bonta. So they're probably no votes. That's our four no votes. Rick Zabur, Josh Lowenthal, Leticia Castillo, and Josh Hoover. That's probably our four no votes. Josh may be a little wobbly, and he'll probably try to play diplomat, but those are, I think, four solid no votes. Um, so Robert Garcia is definitely a yes vote to
Right.
get this bill forward. Mia Bonta. Now, Mia is very interesting because if you look at the record, and if you just look at the record, she voted yes. She voted yes on AB 715, but she gave a very long floor statement explaining why she was voting yes on AB 715. And the reason why was because she had an expectation of 2159 getting introduced. That's the
Oh,
only reason she voted aye. And so we expect that she would support
right.
this bill going forward. And then that leaves us with the vacancy, whoever fills that vacant seat, and then Alvarez and Patel. Those are the three unknowns. And so if we're able to kill it here, that pretty well stops the bill. Now, there's one other piece, and that's the second component is the Speaker of the Assembly. Uh, Now, even if the bill fails here, the Speaker can say, "Listen, we gave your bill a shot. It didn't make it out. You couldn't get your colleagues. There's only two Republicans out of nine people on this committee. Your Democratic colleagues didn't support you. No go. It's not going to go any further."
Right.
I'm not sure that's what's going to happen. I have a feeling that the speaker is going to try to negotiate something because we cannot forget that the CTA will probably jump in at some point. They're playing some power games here this year. Um, there's a lot of money that went in from a lot of these teachers unions to the Prop 50 congressional redistricting, which gave congressional Democrats a couple more
Right.
House seats here in California. So there's some payback that has to happen. So this is going to be a very interesting fight. Pay close attention in the next month or so with what happens to this hearing that may happen within the Education Committee. And we, of course, at ICANN will be giving you detailed updates all along the way. But this is where it stands now.
Okay, thanks, Dylan.
Yeah.
Yeah, and then details along the way, and when you do come up, with whatever that strategy is, whether it's, to the possible swing voters or whatnot, appealing to them or doing some sort of actions in that way, you get us anything, and you know that we will absolutely amplify it.
Thank you. I always
Near
appreciate
far. Um, but look, so overall for everybody listening, and we're definitely going to, play parts of this on socials because I think that this was extremely informative, both laying out AB 17, laying out legislation, how it happens. Ilana, your sort of how to, both look for the problem areas, be involved, and the steps to take, and that California parents know that they can reach out to you with these, with these issues. So we'll definitely be amplifying this on socials. And Gerard, of course, with your infinite knowledge, how you just perfectly explain everything in very, just easily understandable ways is amazing. So I think that's first step. Second step, everyone else as well. Definitely take a look at our an education parent handbook because a lot conceptually of what Ilana was talking about is also sort of outlined there. Just simple to follow and know that we're all always here for all of you. What ICANN, Emmett Legal, obviously Ends Jew Hatred, the Lawfare Project. We're here sort of from every angle. You have the civil rights, the on the ground pressure, social pressure, the legal side, the lobbying piece. So we're all here for you all. And thank you for joining us. Gerard, Ilana, Dylan, first, thank you for your time. But if there's anything that you'd like to add, please go for it, everybody.
I just want to say thank you to you, Michelle, and your hatred for always being great partners, and Gerard, you've always been a phenomenal asset, and Ilana, again, thank you. You've been a great ally in the fight here in California. We couldn't do it without you as a partner. So thank you all.
No, thanks so much,
Well,
everybody.
thank you, Michelle, for organizing and putting
Of
this
course.
together.
Absolutely. So we're here, we're not going anywhere, and staying loud and proud. So everybody reach out with anything any of you need, and much more to come.